So sneak preview there. We've been making lots of videos like this on key cases to make it easier for you to have stories to remember the cases in this module and put them together in an online course. So we hopefully will be live with that next weekend, next week. So we will give you an update on that once it's available, if it's something that anyone would find helpful to have a look at. So Grace, over to you.
Okay, dokie. So I'm going to just share my screen very briefly. So we're going to be going off a couple of slides today. Just to give you a bit of a rundown, I don't want to eat into our 60 minutes very much more, but these books are my bread and butter. I run these sessions quite frequently. And so we've been putting together, as Sam said, some of these online courses. Sam, do you just want to mention as well some of the resources that we have?
Yeah. So I think a few of you have kind of already got these, particularly those of you that are on our course, but if you're after more practice questions and revision cards, then we have these available in bundles for the key exams. So M05 was actually the first one we did this for because we were keen to come up with some revision cards for the cases. So if you're after a little bit extra help, we'll chuck a link into the chat and you can have a look at those later on. And I will be in the chat throughout the session, so Grace will be running through the slides, and if anyone's got any questions at any point, drop them in there to me and I will be coming back to you in there.
Great, thanks Sam. Okay, so we've got 60 minutes just under, just to go through the following. So I'm going to go straight into some of the cases that you need to know. Then we're going to look specifically at legislation and some of the statutes that are very key in this area. As well as the UK legal system. I'm going to give you an overview because this is chapter 1. Chapter 1's so meaty and it's really the foundation of the book. So if you kind of don't get past that session, it's kind of essentially all the stuff that you need to know. And then very finally, we're going to look at key points on tort, another meaty chapter, and contract, which is chapter 3. So Sam mentioned in the introduction that some of you are just looking to do law. Don't be put off by this session. We're going to run through things quite quickly. So essentially, hopefully this gives you a really good framework for what the book is involved with. I have to say, I say this, some of you know this already if you've had me before, but I actually did this backwards. So I did the book first, the M05 book, and then I loved law so much that I did a degree after that. So I've done it a little bit back to front. But it's actually just kind of established a little bit more of my understanding in these areas. So it's a really good book to get your head around. So I'm going to start straight away, as I said, with the cases. The snippet that Sam just played us was from Donoghue and Stevenson, which is in relation to a snail. So I'm going to give you a rundown of these cases as they are on the screen. So my snail little emoji over here. So as I said, the case is Mary Donoghue and Stevenson. The main case in tort law for negligence and duty of care. So as you saw in that animation, what happened in that particular case, Mary Donoghue went with her friend to a cafe. She found that when she poured in her opaque can of ginger beer into her bowl, she had a decomposed snail that had fallen out that made her ill. And because at that time, manufacturers didn't owe a duty of care to their consumers, that was the only kind of route that she had to take it to court. Where they said, right, let's see who owes whom a duty of care, and essentially, where is it reasonably foreseeable that somebody's actions are going to affect other people and actually have caused them injury or harm or loss. So that is one of the key cases. I'm going to go drill down into the test of that a little bit later on when we look at tort. But if you're going to remember one case from the book, this is probably it. Just moving on to my second orange one in the middle of the screen there is, if any of you can figure out what that is, it's Headley Burn, hence the fire, and Heller. And so in this particular case, this is to do with negligent misstatement. And again, one of the tortious elements, so it's kind of a building upon Donoghue and Stevenson. Here, it's kind of in relation to any negligent advice that somebody would give. So if you're down the pub with your mate who's a lawyer and you go, oh, I've got this issue, can I just talk it through with you? You have what is called a special relationship because you are relying on that person to give you legal advice. As such, it's reasonably foreseeable that you're going to take that advice and then act on it. And then if your lawyer friend tells you the wrong advice, even though there's no contract or anything like that, you've just got him on his word, he's kind of had a few pints, he's talking a little bit out of turn. If he causes you loss, you can then go and sue him under this particular principle. So this is why we have professional indemnity insurance. It's the main kind of driver for that. he probably won't be your friend anymore, but it's an option there if necessary. So negligent misstatement is all about the advice that you're giving and then someone relying on that particular piece of advice. So I'll let you guys take notes as you go, but I'm going to kind of move on a little bit swiftly to the left-hand side of the screen, the bottom left corner. This is the wagon mound case. So that's my little hill and that's my wagon on top. So this is to do with remoteness and causation. We're going to be talking about this a couple of times in this particular session. So this was actually a case, believe it or not, it was set in the Sydney Harbour. So it was an Australian case, but we've followed it ever since in English law. And essentially, it was to do with a oil spill. So the defendant spilled oil into Sydney Harbour, it caught alight, and then welding that was being carried out at the claimant's premises then caught alight further because of everything that had happened. It was very unusual circumstances, and the fire realistically shouldn't have spread as quickly as it did. But at that time, long time ago, we didn't actually know that oil could catch fire in that way. So the judge actually turned around and said, sorry, it wasn't reasonably foreseeable that this was going to be the case and this is what was going to happen. And so therefore the case, the wagon mound says, you know, talks about remoteness, and in that particular case it was too remote to actually have the defendants being held liable. Just moving on a little bit further, so we're still staying with tort for the time being. You'll notice that there's a huge majority of cases in chapter 2, which is the law of tort. So I've kind of whittled it down to the few ones that tend to pop up more often than others, but obviously there's so many in the book, so this is to give you the highlights. My top one, if any of you know, is about Alcock. So it's called Alcock and South Yorkshire Police, and it's to do with the Hillsborough disaster in 1989. So some of you might be aware there was a massive crash in a football stadium, which led to many injuries and lots of deaths as well. This area is all encompassed under what we call nervous shock or post-traumatic stress disorder. And essentially you have two different types of victims. You have primary victims, so those who fear for their own life, so those in the stadium perhaps, and then you also have secondary victims. And a couple of cases came out of this from potential secondary victims, and it was essentially members of people's families who were watching the events unfold on the television, and they were knowing that their family members were in the stadium at that time, so they were fearing for their lives, and also help workers or kind of police staff and ambulance staff that were on the scene as well. So lots of people who have potential cases in this area. There was a 3-part test that was made under Alcock, which was essentially to do with looking at making sure that there was a close tie of love and affection with the secondary victim, making sure that you were there in closeness of space and time, and also making sure that you experienced that particular event through your own unaided senses. And they had to make this test quite restrictive purely because they didn't want to open the floodgates. So for example, if any of you knew anybody in the Twin Towers on 9/11, think about all the cases that could actually happen in and around that from secondary victims. So it was really necessary to do that. I will just go on to the very last case on this slide, and then I'll take any questions. I can see the chat kind of lighting up a little bit, so Sam, if you do want to jump in there with any questions on this stuff, then please do. My last case that I just want to flag is actually in the contract side of things. One of the key areas that people go, Grace, I just don't get this, is Estoppel, and sometimes it's partnered with what we call waiver and Estoppel. So let me just tell you the facts of the case, and then I'll tell you the kind of the principle at law. So this is within contract. Promissory estoppel is a equitable principle, which means that it's outside of common law. I'll talk more about that as we go on a little bit further later on. But essentially, in this particular case, we had a block of flats that was let out to tenants. But when the war started, unfortunately, tenants couldn't be found very easily anymore. So the owner of the flats, the freehold, basically said, you know, as long as we can keep getting people in, we're okay to decrease the rent throughout the war period. And then after the war ended in 1945, the owner of the flats tried to go back and get the money and recoup all of their rent from that time. And the court turned around and went, no, they've acted upon what you said, and you promised them that the rent would be reduced during this period. Therefore, you are stopped from going back on your promise. So essentially, in a nutshell, estoppel is somebody creating a statement or a promise, the other party acting on that promise, and then essentially they can't go back on that promise because they've the other party has acted on it, and it would cause them a loss if they were to then go back on that promise. So they are stopped from that particular scenario. We might talk about that a little bit again when we come to the last little section on law of contract. Okay, any questions you want to flag now, Sam, from anything in the chat? If not, don't worry.
I've put myself on mute, but no, we're good.
Okay, all right, lovely. Let's move on then. I know we're going at quite a pace, but hopefully you guys are furiously scribbling down as I'm talking. So these cases aren't so much, these are more to do with the actual principle rather than what happened in the case, but I will give you a little bit of a rundown for some of them. The only reason I put Calistine and Preston in on top, again, you don't need to know the facts of the case, but it comes up maybe 2 or 3 times in this book because it relates to the definition of indemnity and also subrogation. So it's one of the key areas for actually defining what those principles are. So if you remember that in your head, so Calistine Preston goes with indemnity and it goes with subrogation. These 2 middle cases are of the same batch. Okay, so Wayne Tank and Pump and JJ Lloyd, or what we like to call the Miss JJ, because that was the yacht's name in that particular case. What these are is they're to do with causation. So we're in, at this time, I've jumped around a little bit, but we're in chapter 8 of the book. And essentially what these are looking at concurrent causes. So if you remember from your previous studies, you looked at proximate cause, which was the dominant cause of a particular loss. With concurrent causes, it's where maybe 2 or more perils have happened at the same time. The authorities to come out of these particular cases, for Wayne Tank and Pump, it said that if there is an insured peril and it's partnered with an excluded peril, the exclusion prevails and insurers don't have to pay anything. However, in the Miss JJ, or the JJ Lloyd case, just one below that, it said that if you've got an insured peril and an uninsured peril, and that an uninsured peril, remember, is something that's just completely omitted from the policy wording entirely. It's something that is neither included or excluded specifically. And so when you've got an insured and an uninsured, then essentially the insured part of it prevails, and then insurers would be liable for the whole loss. Okay, so just get round your in your heads those 2 different scenarios, because I do see that in questions quite a lot. And then very finally on this particular slide, we have Wattu and Fenwick. Some of you might have come across this already. Sometimes in your previous studies you might have looked at law of agency, and so this is the area that it comes from. In this particular case, I always think of, I don't know why, I always associate this with Wetherspoons, because there was a manager of a pub and his name was above the door. But the overriding kind of chain was Fenwick, which was our kind of Wetherspoons brand, if you like, for modern day. And the manager of the pub purchased cigars, a whole kind of crate of cigars from Wattu. And Wattu didn't realise that he'd been specifically prohibited from actually purchasing cigars. He was what we call an agent of a principal, but he had what is referred to as apparent or ostensible authority. So some of you guys might remember this from the law of agency. Technically, you have a 3-party relationship. So you have your principal, you have your agent, and then you have your third party. And more often than not, the third party has no kind of idea of the setup or the relationship between the principal and the agent. So whatever the agent does on behalf of the principal, unfortunately ends up binding the principal in most circumstances. So in this particular case, the owner of the pub was bound to actually pay for the cigars that his manager had ordered on behalf of the pub. So that is the key case in that particular area, and that comes up quite a lot as well. Okay, so moving on from cases, we will maybe talk about a few other cases as if they come up a little bit more probably in the tort section later on. Let's talk about statutes. So again, statutes they get a bit of a bad rap here. There are quite a few of them. This particular book has a case index and a statute index. If you've been through the book thoroughly, you will have seen that already. You might have heard me say before as well, the day before our exam, I do like a little index checklist. So I basically go through the index and just make sure that I know kind of roughly what each statute and case is referring to. And if I don't have any idea, looking it up helps to just get it in my memory. So here we're looking at statutes. So these are things that have been written into law specifically. They are pieces of legislation that have gone through the Houses of Parliament, which we'll talk a little bit more about in the next kind of section. And the key ones that I've drilled down, I've got maybe 2 slides on the statutes that you need to know, but I know that there are lots there, but I just wanted to pull out these key ones here. So I get so tired of saying this all the time. I call the top one CIDRA because it's so long-winded, but I will spell it out. So Consumer Insurance Disclosure and Representations Act, bit of a mouthful, but it's to do with the overriding, essentially, of what we used to have, the Marine Insurance Act 1906. And we were basing all of our kind of legal aspects on that act. So we were going, oh, we've got a cyber policy here. What does the Marine Insurance Act say about it? Well, that was written over 100 years ago and it wasn't really in keeping with the times. So we updated this. This came into play